Let's stay with some court news. Jacob Zuma's sentence will not be overturned. He applied for a rescission after he was sentenced to 15 months in jail, but a majority in the Constitutional Court found he did not meet the requirements. Zuma will also have to pay the legal costs of the application. Justice Clement Manyathela handed down the judgment a little earlier this morning.
The majority of the Constitutional Court makes the following order. 1. Direct access is granted. 2. Counsel for the advancement of the South African Constitution and democracy in action are admitted as amici curiae. 3. The application for rescission is dismissed. 4. Mr. Jacob Zuma is ordered to pay the cost of the Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, and Raymond Mnyamezeli Zondo, NO, including the cost of 2 counsel. I hand down the judgment.
Let's speak to Dan Mafora, who is a research officer at Casac, for more on that judgment. Dan, thank you so much for making time. Legal, skullduggery, litigious, vacillation, some of the words used by Justice Khampepe in delivering that judgment. It was a straightforward matter, wasn't it?
Thank you so much for having me, Clement. And yes, it was a very straightforward matter. I think as we spoke before, I indicated that rescission was a very unique remedy that the courts don't usually grant, and we did not expect this case to be any different, particularly because of just like the facts of the case and how it came about.
As Casac, you made submissions against granting rescission. Justice Khampepe clearly outlined the law on rescission, the principle of finality in litigation, and even explained why the grounds for rescission must not be expanded. Why was that a victory for the rule of law?
So, I mean, we made submissions as Casac to say that the finality of litigation is an important aspect of the rule of law, that litigants must accept court rulings as final, even when they don't agree with them. And that's important because once you do not have an end to the litigation process, there is no legal certainty, and people are not able to plan their lives accordingly because they don't know what the law is. If I'm allowed, as someone who has been granted or against whom a judgment has been granted, to seek to overturn that judgment over and over and over on the same facts, that poses a risk to the certainty of the rule of law, and therefore it is important that judgments be accepted as final, and we are very happy that the court has agreed and has restated this very important principle.
So is the matter now final? Because there's now the issue of international law that's been brought to the fore. I was talking to Clement Manyathela earlier, who's the spokesperson for the Jacob Zuma Foundation, who's now talking about some treaties that the country is a signatory to. So that issue of international law, how does it come about, and what would be their approach really if they want to challenge this on that basis of international law?
So, I mean, it will be very interesting to see, and I don't think it has ever been done before. But what Justice Jafta says in his dissent is that the former president might have a claim against the state of South Africa at international law level by invoking the provisions of the relevant covenant, the ICCPR. But I mean, it's as Justice Khampepe makes the point, which I think is correct, that the convention itself is not a part of South African law, but only binds South Africa at an international level. I don't know whether or not Justice Jafta's statement that Mr. Zuma might have a claim against the state is correct, but certainly if that is an avenue that will be available to him, he might take it further. But as far as the South African courts are concerned, this is the end of the matter.
Yeah. So the former president is already on medical parole, and some people have been asking, is this moot, this judgment, does it matter? Why was it important? Because there are some important principles of law that came out of the judgment today.
No, absolutely. So I think it's important to separate the two. That this rescission application dealt with something very specific, and that everything else that happened after that doesn't have an impact on what the court said today. So whether or not Mr. Zuma has been granted medical parole, whether or not that medical parole was properly granted is a completely different discussion for later, or for another court, as we've seen the challenges that are in the courts right now. But it was important for the court to clarify and to lay out the specific terms under which a rescission would be granted, and to make it clear that the circumstances are very limited. And you'll remember as well, Clement, just to finish off, that the public protector herself has filed a rescission application following the court having heard this particular one. And so that is kind of like the court saying, look, this is how rescissions are supposed to be brought, and this is these are the only bases that we will grant them on.
Yes, and the grounds need to remain narrowed, Justice Kampepe was stressing during that judgment. Thanks for making time, Dan. Always appreciate your time. Dan Mafora is a research officer at the Council for the Advancement of the South African Constitution.